Well, okay, so I think we can officially maybe get started. Before we present to Mr. Victor, I just wanted to share we are starting our undergraduate certificate on innovation and entrepreneurship, which I'll start teaching in the fall. So if you have electives or you would like to have the certificate as an extra to your major, now is the time to get registered. We do have scholarships available, so if it's like extra to your tuition, I want to make sure that you're covered and you can probably get the certificate for free. Okay, so please share this around and also share with your friends. We are trying to have a full capacity of 30 students, and the cool part is we'll actually be in the new building at the Independence Hall. So if you want to have a class and be in the new building, this will be the time to do so. All right, so that's my last plug. Also, a little bit about the Center for Entrepreneurship. Oh, sorry. Present. The McNair Center for Entrepreneurship is here for you. So if you have an idea or if you have like a business and you kind of want to, grow your business or need some guidance, please feel free to come and share those thoughts with me. I'll be the one sort of plugging up with resources. We have now an advisory board where they can also help you with community and resources outside the school. So I just, want to create this community. At some point, we'll even have a club for entrepreneurs driven by students. So, hang in there. I know a couple there's a seniors, but if you're like a sophomore and you're interested into this, please just come to our workshops. I know this is the last time of the semester. For the summer, I'll be sort of focusing on youth entrepreneurs. So we do have summer camps for middle school and high school students. So if you want to be an intern and helping them, if you're available, that will be a paid stipend for you. Come to me. We do have that for 3 weeks in July and 2 weeks as a volunteer for in June. All right. Any questions? You're all good? Okay. So Mr. Victor, it's all yours. Thank you so much for being here and sharing your expertise with us.
Thank you, Brenda.
Yeah.
Yes, I want to, again, thank you, Brenda, for this opportunity. I've been wanting to come and teach some about intellectual property for a while now, and I'm a big believer in Houston Baptist University and all the programs. So a little background about myself. I'm an intellectual property attorney. I've been practicing now for 24 years. And mine is one of those professions where I can actually give you my disclaimer up front that I'm practicing. You never hear of a practicing educator or practicing accountant or practicing architect. So somehow we get away with it. So if this is your moment, then if you think you may have somehow entered the wrong presentation, I don't mind if you leave. No, just kidding. Anyway, all jokes aside. Before I got into patent law, to give you a little bit of my testimony, I started off as an electrical engineer. That's what I thought my passion, that's where I thought my passion would lie. Graduated as an engineer. Was fortunate enough to join a team. They sent me to Mexico City. I speak Spanish, and they needed an engineering team. I was chosen, got to go. It was a great opportunity. My contract ended, and my employers, the people in management, they wanted me to stay on. They flew me up north to interview with the headquarters to see if I'd get a full-time position in a management level. And I just tell you, before the interview, I was a little unsure if I still wanted to stick with engineering, if I still wanted to stick with this particular company. So I remembered Psalm 37:5. The Lord tells us, commit your way to the Lord, trust in him, and he shall bring it to pass. That's what I did. Before the interview, I prayed to the Lord, guide me. If this is for me, this is the path you want for me, help me make it so. If not, I trust in you, show me. Long story short, I went to the interview. I thought I had done well. They flew me back to Mexico City. The news came down that I had not been chosen for the position. My supervisors, everybody was shocked. They couldn't understand why. And neither did I at the time. But I accepted it, as that's just not a door that was meant to be open for me. And after that, it just came to me about patents. I had known about patents in undergraduate as an engineer. I dug a little deeper into it and realized it's a very great field. You can keep one foot in law, one foot in engineering. And long story short, that's why I ended up as a patent attorney, and I've never looked back. It's a great career. For those of you that you may not be sure if you've chosen the right career path, the right discipline, committed to the Lord, He'll guide you. All right, that being said, let's get started here. If you have any questions, feel free to ask me during the presentation. If it's going to be coming up in future slides, I'll let you know, otherwise I'll field them, but feel free. I'm not sure why. Wait a minute, I think I'm going backwards. There we go, okay. So, what is intellectual property? I think the first thought that comes to mind is that they are creations of the mind, creative works or ideas embodied in a form that can be shared or can enable others to recreate, emulate, or manufacture them. I think that's pretty well understood. Types of IP, and these are the four specific types of IP I'm going to be discussing this afternoon: patents, trademarks, copyright, and trade secret. The thing about IP is when people talk about it, I have found that unless you're immersed in it, typically there's a little bit of confusion. The thing to keep in mind is the IP, it's really tied to the relationship of whatever the particular article you're talking about. So for instance, with patents, when we're talking about them, we're talking about something that covers the form or the function. Trademarks, branding. I think copyright, expression of thought. And trade secrets, of course, is that secret sauce information. First topic before I jump to it, little side note here. The U.S. was the first nation to codify the protection of intellectual property in our Constitution. It's Article 1, Section 8, Clause 8. This is the literal language: to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The key wording to note is, okay, it was for science and the useful arts. So the Copyright Act and the Patent Act, they're by federal statute. Trademarks, they didn't come under federal statute initially, not under the province of the Constitution. But initially that was the forethought of the founders for works of art and science. Another key thing to note here is we're going to focus in the presentation. What they give you really is the exclusive rights. And that's the thing to keep in mind. When you own a type of IP, you own a certain bundle of exclusivity. And I'll get into that. So let's start off with trademarks. Everybody's, I'm sure, familiar. We see these things every day. You can't go anywhere in the world without seeing trademarks. So what are they? They're words, devices, symbols, or combinations that identify, source identifier. If you weren't aware of it, this has been broadened. You can now also get a registration, trademark registration, for smells, sounds. For instance, the Intel, the little chime that's for Intel, that's trademarked. For color, Dow Corning's insulation, that peach kind of salmon color, that's trademarked. So it's been broadened. You can trademark many different types of things. The key is to identify the source of the goods, to distinguish them from the goods of others. And what rights do a trademark give you? They give you the right to prevent others from using the same or a confusingly similar mark. And confusingly similar, that's the key for proving trademark infringement. So if you have a trademark and you believe somebody's infringing, you don't have to prove actual infringement. The basic threshold is if it's confusingly similar. If you have actual confusion, I mean, that's a no-brainer, then you've got a winning case. But as long as you get to the threshold of confusing similar, and that's what you want to avoid if you're selecting a mark. You want to stay away from others as possible, because if you fall in that range of confusingly similar, then you may be facing an infringement suit yourself. The types, everybody familiar with the term trademarks, but then you may have heard service marks. They're the same thing, the exception being that service mark covers the source of a service versus a good. Like if I have an Apple computer, I would say my trademark is the Apple emblem. But if I say I have, I don't know, Sam's Accounting or give it some fancy name, then I would have a service mark because it's identifying my service. So we say they're service marks. But if you say trademarks for service marks, people understand, same thing. Now, they're issued federal registration. They're issued for 10 years. You have to file an affidavit after 5 years to substantiate your use. You have to renew them. They're not forever lasting. You have to renew for 10-year periods increments. If you don't do that, then basically you lose your registration and you'd have to file some petition to get it renewed. Question? To file, register. So the question, how much does it cost to file for trademark registration? That's an excellent question. The way the system is set up, it's based on what they call classes. So let's say you have, let's say a chair. That's a good. You want to sell your particular chair. You'd have to look through the directory and say, okay, which classes do I want to put this under? Do I want to put this, for example, one class may cover furniture. Another class may cover home goods. Just giving you an example. So you may choose classes, and you pay per class. I believe it's roughly in the $200 range per class, and then you have a nominal filing fee, and then if you want to do it yourself or if you want to hire an attorney. So ballpark it, I would say for one class, for one good, and if you hire an attorney, you're looking at probably $500 to $1,000. It doesn't matter. It depends on the classes. How many classes do you choose? There's no, the schedule for the pricing doesn't vary on prominence. Before the trademark examiner, they just look at them as trademarks. Classes, they're just a designation that if you go to the Patent and Trademark Office and you look up the trademark portal to file for a registration, it'll prompt you under which class do you want to designate your, let's say, a good or a service. And they have a list. So you have to select. For example, if it's services, it'll be a list. Class 1, and this is an example. Class 1 may say our accounting. Class 2 may be engineering. Class 3 may be educational purposes. So you have to designate in your trademark application under which class do you want this mark to be protected. And that's an excellent question, because when you look at a registration for these trademarks, I said the standard is confusingly similar for infringement. But then you might ask, well, how come there's this mark here for this type of good, and there's this other mark here that's very close? How do they get a registration? The reason being is what you look at is in the classes, the description. What does this mark cover? And it's very important when you do your application that you're very specific on what it is you're trying to protect, because you will have to submit a specimen, a sample, a photograph of what it is you're trying to protect under that mark. So that prevents the public from doing a wholesale. For instance, I can't say, okay, I want, I don't know, Jiminy's car wash. I can't say, oh, I want this to protect not only a car wash service, I want it to protect accounting. I want it, all this a laundry list. You can't do that. You have to divide it out, and you have to show specimens, proof that you're using it in that manner. So that's where the classes come in. And the description of the goods, when you do a search, if you're trying to pick a mark, that's what you look very closely at, the descriptions, to see that even if you have a mark that's confusingly similar, it may still be registrable if your goods are so distinct that the public won't be confused, because that's where the confusingly similar comes into place. Who's confused? The consumer. Oh, I left out proper attribution here, or providing notice. This is important too. You will often see the little symbol next to somebody, the TM or the circle R. The TM, it just means that you are holding that out as a trademark. You can use that at any time, even before you file an application. If you're legitimately holding your mark out, you want the world to know, hey, this is my trademark. It gives you a certain level of common law, we call common law rights. But to really protect it, you'd want to file an application, because once you get a federal registration, it covers the whole US. So even if you don't sell your products, let's say in Pennsylvania, but you have a federal registration, your mark is protected in Pennsylvania if it's federally registered. And that's when you can legally use that circle R, once you get the registration. So my advice is if you're not ready to file for an application, but you want to hold it out, put the TM symbol on it. Proper attribution, this is for when you are wanting to use others' trademarks, perhaps to do a comparison of your goods or a description. You can legally do this. You can legally say, okay, I'm offering my product and mine has an improvement over competitor X's, and that's where you put competitor X's trademark. You can legally do that, and you won't get into trouble if you give proper attribution, meaning you will often see this in ads. You might see a little parenthetical saying, X trademark is not affiliated with us, or is not a spot endorser of our goods. Give proper disclaimer, who owns the mark, and that they are not endorsing your product. Right? Those are the little cautions you need to take if you're going to use others' marks in your advertising. Choosing a mark. So here I'm showing a spectrum from weakest to strongest in terms of the type of mark. So if you look on the left, so what we call generic marks, these at one point, salt, aspirin, jeans, elevator, tissue, zipper, at one point they were trademarks. They were being held as legitimate trademarks. Over time, they became generic, meaning that they lost their ability to identify the source. I mean, now if you say aspirin, only a handful will remember, oh, that was Bayer Company. At this point, it's just aspirin. All right, so selecting descriptive are the marks that give you an idea of what it is. Quick Print, Computerland, E-Trade. If the mark itself kind of gives you an idea, that's why it's on that end of the spectrum. Suggestive, Chicken of the Sea, Coppertone, Microsoft. They're not as descriptive, but they give you some suggestion. And so we're going from left is the weakest to the strongest. When you get into the arbitrary range, that's where you want to be, or fanciful. Because think of the Apple logo. It's arbitrary in relation to the goods. Who would have thought this emblem has any relation to computers? I mean, now we do, because that's the power of it. But initially, or Penguin or Shell, the best are the fanciful, basically created marks. Kodak, Exxon, when they first rolled them out, nobody thought of Kodak with cameras. Now we do, and that's the power of it. So if you're going to select a trademark, look at the spectrum, and you want to go fanciful is something that people will not automatically have a suggestion or a description of the goods. A terrible example of a descriptive mark is if you go near the airport, there's that where you can park your car before you fly. The literal sign says park and fly. There's no guesswork there. You can't get a trademark. It's descriptive, right? There's no power, no source identifier. All right, let's move on to copyright. So what's protected? Original works fixed in a tangible medium of expression, and the rights begin at the moment of fixation. So basically any original expression you have, as long as you put it down on something. If you're at a party and you come up with this idea for a slogan and you put it down on a napkin, you have an automatic copyright on what you put on that napkin. It's fixed in a tangible medium of expression. The key being that it's original, an original work. So they come into being pretty automatically. There's no magic there, nothing to file, not for the creation. So what is protected? Literature, photographs, motion pictures, musical works, sound recordings, software, plans, designs, sculpture, architecture. Quite a broad range of items and things you can protect via copyright. What is not protected? Ideas, concept, or discoveries. That's where the patents come in, which we'll get to. Titles, names, short phrases, slogans, generally not protectable by copyright. And if the work is not fixed in a tangible medium of expression, then it certainly isn't, because there's nothing how can you prove some original authorship if it doesn't have some tangible medium? So if I give you the speech and I never put it on paper or never record it, then I can't say I have a copyright on this verbal speech. Works consisting entirely of information commonly available or that contain no originality. Basically, this would be facts. Facts are not copyrightable. There's a famous Supreme Court case where before a lot of you may have never seen an actual phone directory where the paper where you had this thick, they use them this chair boosters, where you actually had businesses and residences and people's names and addresses. Well, the famous Supreme Court case where one company took a phone book, copied it, just gave it a different little color, different form. So they were sued for copyright infringement. Supreme Court decided, sorry, these are facts. People's names, residence, addresses, etc. Cannot copyright that. The only thing that is copyrightable would be the form of the expression, the form of the layout. If you use some coloration, some font, some artwork, that's protectable, but not facts. So anything written or created by the US government, that's also not copyrightable. So you can use that. If you find something put out by the Patent and Trademark Office, for instance, if you want to cite it in an article you write, some educational work, you can feel safe that you're not infringing a copyright because it's produced by the US government. Oh, and I should have said this at the beginning of the presentation. Most of what I'm telling you here is applicable to US law. I mean, I'm a US intellectual property attorney, so that's my bailiwick. I will tell you some distinctions for foreign laws as they come along, but for the most part, most countries' laws, they're pretty uniform. But just know, what I'm telling you primarily applies to the US. And this is why, if you seek patent protection overseas, you want a patent in Mexico and France, you will have to go through a local patent attorney or patent agent in France, because you have to be registered. And as a US registered attorney, I can't represent you before the French patent office, and vice versa. So copyright, what are the rights? You prevent others from making copies, modifying the work, distributing the work, performing the work publicly, displaying the work publicly. So the owner controls all of these uses. The reason I have this bundle of sticks here is because this is the way you should think of IP. The different forms of IP, they give you bundles of rights. So if you have a copyright, one of your sticks is the right to make a copy. The reason I want you to understand this is because when you think of licensing or authorizing others, you can parse out those rights. If you want somebody to make copies, or somebody wants to, and they come to you, can they get a license? You craft it carefully, so all you license is that one stick. Okay, you have the right to do the copies, but you can't perform it publicly, or you can't display it, etc. So you can give out the wholesale copyright license to everything, or you can license out individual sticks and take licenses for that. So if you're having a deal with a party that you want to use some of their material, keep that in mind. If all you want to do is display it, approach them in that manner. I'd like a license solely to display. So you be aware of that. The fair use doctrine. This applies in copyright law. It allows limited use of the copyrights of others without requiring permission. It's reserved for commentary, criticism, news reporting, research, teaching, or scholarship. This is why educators can legally photograph.
Your mic is
Sure. Technical glitch. It's okay. Thanks. It's on? Okay. Okay. So as I was saying, the fair use doctrine is the loophole, if you will, that allows for some usage of others' copyrights without permission. This is why today probably some of your professors will give you handouts of third parties' materials from some texts, from some treatise. They're not violating copyright law because they're using it for educational purposes, for research. But it has to meet 4 factors. And it has to meet these are the 4 factors that are looked at by a court or trier of fact if they're looking at it. You would look at the purpose and the character of the use, including whether such use is of commercial nature, for nonprofit or educational purposes. The trier of fact would also look at the nature of the work. Is this a very highly technical material, or is this something that is just a composition of some factual matter? They give different weights. The amount and substantiality of the portion of the work, if you're just taking one page out of a book, that's clearly goes closer to the fair use versus an unfair use, versus you're copying the entire book. And lastly is the effect or the use and the potential market for or value of the work. And this always goes to the damages aspect, because if there is ever infringement of intellectual property, one of the key components to that is the damages. What did the copyright holder, how was that person damaged? Typically, it's in monetary terms. So these are the 4 factors you would consider for fair use. So just be aware that you may not need permission if you are using it for these purposes and you consider these factors. Question?
Yeah, what does it mean by scholarship?
Scholarship, it kind of goes the same, teaching or scholarship. I'm not really sure the key distinction there. Basically, anything for academic purposes. Is copyright registration required? The answer is no. You don't have to register it, but it's important because unless you register, you may not be able to sue for copyright infringement. So even though I said at the beginning the copyright is automatic upon fixation, if you want to sue to enforce it, it's advisable to register it. And you do that before the Copyright Office. You submit an application. You may not recover statutory damages or attorney's fees until it's registered. The Copyright Act is very specific in terms of how it has a schedule for damages, unlike some of the other IP avenues which don't have a set fee schedule. Copyright Act actually does. And I can tell you from experience, it can be pretty stiff because the way the Copyright Act is worded, some would say it's a little bit draconian because it actually charges you a damage fee per work. So if you infringe and you send out 500, let's say 500 infringing works, you're going to get hit for 500 times whatever that schedule says per work. That's why I say it's a bit draconian. That's why copyrighted people tend to overlook it, but it can bite you. Without the registration, it's just the burden of proof. The certificate is what you get when you register it. It's prima facie proof that the copyright is legitimate. So bottom line is, if you want to ultimately protect your copyright, submit an application to the Copyright Office to get a certificate of registration. Moving on to trade secrets. What are trade secrets? I think most people have a general understanding, but the legal term is it's information that provides economic value or a commercial advantage to those who know it, not generally known to those who can take economic advantage of it, and I say and because it needs to meet all 3, the subject of reasonable efforts to maintain secrecy. The key word here is being reasonable. You don't have to have a guard standing before a door and you say, oh, behind this is my trade secrets. You don't have to go to that extreme. As long as you can show reasonable efforts to protect, keep it secret, then you meet the requirement. You have a trade secret. This is very important for us, particularly a lot of companies, they drop the ball here because a lot of companies have trade secrets. And if an issue arises, typically of the prongs that the courts, the defense attorney will look at and hang their hand on, it's going to be the reasonable efforts, typically, because somehow they didn't put some basic measures in. I mean, some simple things. For one thing, if you have a group of engineers or students or whomever is on your project team, and you guys designate, this is a trade secret, everyone on that team should be aware this is not a trade secret. Because if one of your members leaves, goes to a competitor, and they start producing the same thing, and you realize, hey, they're using our trade secret, you go to enforce it. If that person says, hey, nobody ever told me, it goes to the reasonable efforts. So the term here, we don't say you're infringing a trade secret, you say you misappropriation. That's the legal term. So it's use or disclosure in violation of an obligation of confidence, if it's either expressed or implied. Express would be if you're violating a confidentiality agreement, just basically an agreement you would sign saying, I agree to keep this in confidence. The implied is more in relationships, the employer-employee. So even here at the university, if you start working for some departments, you'll be made privy to certain information. And there's an implied, not so much a right, it's implied duty to keep that in confidence. So that's how you can misappropriate, by violating certain obligations. The use of improper means to obtain the secret. I mean, this is a no-brainer, right? If you break into some office that is locked and you know there's some information in there, That's misappropriation. Espionage, of course, is the big one. Reverse engineering of a publicly available product usually will not be considered improper means. So this is what a lot of technology companies do. They'll buy the products legitimately, and you can reverse engineer, and that's just the way the world works. If I can reverse engineer and figure it out, you've lost your trade secret, generally. I mean, there may be, if you've got a pattern perhaps of, you've been busted before for sending moles, to commit espionage, yeah, the court may not look favorably on that, but in general, as long as you do it properly, you'll get away with, I don't want to say get away, but you won't be misappropriating. Independent development, legitimate acquisition from other sources also will not be considered improper means. So if you independently develop somebody else's trade secret, that's the world, and you're okay. How can the trade secret rights be lost? Generally, when the secret the secret dies when secrecy is lost. I mean, that's kind of self-explanatory there, but a lot of times, and I'm just giving you some of the pitfalls that people commit, they publish the secret, and not that they do it intentionally. Typically, it happens sometimes at universities. When you have your graduate students working on something, and we all know academia, you have to publish or perish. And somebody will put something in there, they didn't screen it properly, and lo and behold, something we wanted to keep secret got published. Patenting the secret. When we get the patents, when you go into that, you have to give a certain amount of description in your patent application. So the question is, do you want to give the trade secret away or not? Because if you do in the patent, it's public. Improper protection, again, it goes to the reasonable measures. If you had a trade secret on your team and you never told anybody it was trade secret and they all left and started using it, you're probably not going to be able to sustain it in proper protection. And then I mentioned reverse engineering. So how do you safeguard them? The basics recommended is need to know disclosure, use of non-disclosure agreements, also referred to as confidentiality agreements, they're one and the same thing, and reasonable security measures, restricted access, securing documentation, marking the materials, and I mentioned before, everyone on the holder of the secret should know. And when I was in-house counsel, what we would do is we'd have all our engineers sign a document stating they were aware that X information is trade secret. This way, there was never any issue. If any of them left and an issue arose, no one could ever claim ignorance. And of course, preventing publication was built in. Moving on to patents, my favorite area. This is where my passion lies in patents. What I'm showing you here is, if you're familiar with Phil Robertson, the Duck Dynasty clan, this was his original patent, which is now expired, but this was the patent. On the left side, this is what you'll see. Typically, this is the cover page of most patents. You'll have some title language, the inventor's names, the dates of publication, filing, etc., and an abstract. What I'm showing you on the right is most patents, especially utility patents, have figures. So those are Phil's drawings for his original duck commander duck call. So what's the power of patents? They give you the right to prevent others from making, using, selling, offering to sell, or importing the claimed invention. Think about those bundle of rights. They're very powerful. You can prevent others from importing, offering to sell. That's incredible. I can stop you from offering to sell something if it's infringing my patented claim. Very powerful set of rights. You can enforce the patent even if the other party independently creates the infringing article. There's no copying element involved here. If you have a valid patent and your neighbor comes up with the same thing, even though they may have done it on their own, never looking at your patent, you have the patent, you predate it, they're infringing, you can exclude them if you want to. Protectable subject matter, machines, apparatus, methods, compositions of matter, and improvements therein. So most patents, most people are aware of, you think of an article, a good, something tangible. It also protects processes. Think of software. Microsofts of the world, they wouldn't exist without their patents, but they're not tangible goods, right? They're software. So that's where it comes under methods. We protect software and other things such as that under methods. Oh, what I'm showing you here is I don't know if anybody's familiar. These are the This is the drawing for the lady that attained the patent on Spanx. $1 billion industry. Yeah. And she probably wouldn't have been able to keep that, the revenue going if she had not patented it. And it goes to what I'm saying, those rights to exclude others from selling, et cetera. So what's the criteria for patents? The 3 standards, and these are pretty much across the world. They use the same standards. They give them different names. In Europe, instead of saying non-obvious, it's called inventive step, but same thing. So if you want to get a patent on your invention, you're going to have to pass these 3 hurdles before the patent examiner. Number 1 is your invention novel? Is your invention useful? And is it non-obvious in light of everything that exists in the world prior to your invention? I can tell you from experience, I've never had an issue with the examiner rejected our application on lack of usefulness. Nobody files a patent on something that's not useful. It has some use. Novelty, you can overcome that. Either it exists, either the same thing you're trying to patent already exists, or it doesn't. You can overcome that. The biggest hurdle that you face, patentees, applicants, is in the non-obviousness. Because the examiners, they're human beings, right? The examiners are allowed to combine what we call prior art. They're allowed to take this publication, that prior patent, that reference, that book, and they're allowed to form an argument saying that if they took little pieces of all of this, your invention would be obvious in light of this combination. That's very tough to argue, and the Supreme Court has given examiners a lot of power in the US to, 9 out of 10 times when you get a rejection, obviousness will always be in there. Although the last few years, it's gotten much more difficult to patent software or computer implemented procedures, because the threshold for what is patentable that's been raised for business methods and for for software. But these are the 3 basic criteria that for patenting. What kind of patents do we have in the US? Utility, design, and plant. Utility are probably 99% of the patents you will ever encounter. They cover the actual goods, processes, like this could have a patent, this could have a patent. Design is the ornamental design. That covers the literal view, if you will, of the article. Some of these may be very useful. I don't know, I want to say Gucci has them, perhaps on the purses. Like if you look at the actual style, like if you were to do a silhouette and you recognize, oh, that's a Gucci, that's coverable by a design patent. I don't highly recommend them unless you have something that the ornamental design is the key feature. The reason I don't really recommend them if you have an article, because the way to get around the design patent is make sure you alter your design somehow enough to get out of the scope. So if you're trying to protect some tangible good, design patents are really, in my view, they're weak protection. Plant patents, I've yet to file, I've never filed one. These are for asexually reproducing plants. Basically, this is for the horticulturists who come up with their own new breed, they create it themselves. You cannot patent a naturally occurring plant. But like I say, it's not my area. I'm sure there's some people that are active in that area. I've never filed one. Enforceability, this is important. So when people talk of patents, they think, oh, they got a patent on this, or somebody might threaten you. Hey, we have a patent now, you better be careful. But the number one question is, okay, are we talking about an actual patent or a patent application? Because it's a process. It takes about 2 years on average between the time you file an application and you get your patent. Until it's granted, you really have no enforceable rights. All you can do is make a lot of noise. So I always ask, is it granted? Are we talking about a patent or are we talking about a publication? Also, during the examination process, sometimes the examiners, they will not budge from the rejection. And if the applicant gives up, you basically walk away from the application. You abandon it. But the general public doesn't know. There's no notice that goes out, oh, this application is abandoned. You have to know how to look at the database and find that notice, abandoned. So, because I get this a lot. I get sometimes like, oh, hey, look at this. Can we continue doing our product? And I look, oh, we're just talking about a published application. So number one, and second thing is jurisdiction. U.S. patents are only enforceable in the U.S. territory, in U.S. and U.S. territories, vice versa. French patent is not enforceable in America. U.S. patent is not enforceable in the U.K., et cetera. If you want to, some people talk of, oh, let's get patents throughout the world. And all I could say to that is, I hope you're a multimillionaire because, because you're going to have to patent in each country for the jurisdiction. So U.S. patents, just keep that, they're good U.S. territories. There are a couple of provisions in there that allow you to actually reach a little bit beyond our shores, and that is, if somebody goes to manufacture somebody outside of the U.S. and for the purpose to avoid your patent, there are some provisions in the statute. You may still be able to go after them, but very specific cases. Priority is first to file. So if you're working on your widget, your neighbor's working on the same widget, if you beat them to the patent office, you file today, they file tomorrow, too bad for your neighbor. It is literally first to file. You made it to the patent office first, you won. Up until 2011, we were first to conceive, which was it was a standard. Basically, you had to show that even though somebody beat you to the patent office, you conceived it first. You came up with it first. And this had a whole field of patent attorneys that specialized just in defending those cases. And it all came down to who had the better corroborating evidence. Because that's what you'd have to prove. You'd have to prove I have logbooks, I have people that can testify, blah, blah, all that, you have to show like you can. And 2011, we joined the rest of the world because we were the last holdout. America was the last holdout. We were still first to conceive. And I knew this was coming when I started practicing it. We eventually were going to go to first to file. It levels the playing field. It's just, that's what it comes down to. Get to the patent office first. An inventor, this is very important. I run into this quite often. The inventor, the legal standard is if you took an active role independently conceiving a design covered by a claim, then you can list yourself as an inventor on a patent application. Because what I used to encounter when I was in-house counsel is people would name others simply because they were on their team or they were their manager. So they felt like pressure. I got to list my man. Problem with that is that you may get away with it. But what people don't realize is if you get the patent and it becomes valuable and your competitor wants to practice that and you get to the point of there's a legal dispute, you're probably familiar with what a deposition is, right? The attorneys would call in the inventors from the other side, sit down, show me on this patent, what did you contribute? If you can't substantiate that, your patent could be rendered invalid. So it's a very serious issue, and I stress this a lot to people. If I see a list with 6, 7 inventors, I want to make sure they're all legal inventors. Otherwise, you may be filing an illegitimate application. Oh, and it's 20 years currently in the U.S., 20 years from the priority date. And I say priority date simply because sometimes you can file abroad and still get piggyback off that application. Most people think of it 20 years from your filing date. But just 20 years is your life. I should say, some people think, I've had this question a lot, where it's like, oh, how can I extend my patent? You can't. The patent office standard is 20 years. What you may see is, if the patent office drags their feet in the examination and they take it longer than average, they will give you extra time to the life of your patent. It'll be stated on the front, remember that front cover, Phil Robertson's patent? That's where you'll see it. You'll see a little asterisk, it'll say extended period for however many days. That's because the patent office recognizes they delayed the examination, so that to your benefit, you should get that extra time. So when you're looking at others' patents for clearance, that's part of the analysis. When does this patent actually expire? All right, what's the process? It's simple, right? The inventor has to conceive the invention. I call this, the prior art search. This is optional. You don't have a duty to search, but it's recommended because otherwise you may be wasting your money. If you file on something that's already out there, the examiners are going to find it, they're going to reject you, and you may have just wasted all the money. So prior art search, this I recommend. Draft the application. You file it, obviously, at the patent office. The Patent and Trademark Office examination. I've seen some. It usually takes about a year to a year and a half between the time you file and you get the first report. I've seen some as fast as 6 months. And there is a procedure now that you can pay extra money to get your examination expedited. But it's like not everybody wants to shell out an extra $1,500 or $2,000. Like, okay, place it on the top of the queue. But you can do that. So on average, it's about a year, let's say, to get the first report. And it gets published. 18 months after you file, the application is published to the world. And this is a good thing, because again, the US also was one of the holdouts. We used to have what were called submarine patents, where you'd be practicing your business, your manufacturing. All of a sudden, poof, out of nowhere, this patent was issued. And you never saw it coming. And all of a sudden, you're an infringer. But now, 18 months after filing, they all get published. So there's a lot of outfit services that track. And you can do it too. You can go to the patent office websites, and nowadays the software is sophisticated. You can set up a watch. Let's say you're inventing or working on, I don't know, some new software. You want, hey, does anybody else have a patent? Go in there, create a search, and it'll ping you every time something publishes relating to that. So there is one way I should tell you that if you can still avoid publication, but you have to upfront give up the right to publish, to patent abroad. When you're filing the application in the US, you have to select upfront. Do I want to leave it open to file this application in other countries? If you select no, then you can opt, say, no, I don't want it published until it grants. It would be truly a submarine patent. No, the world's not going to know it exists until it grants. But up front, you have given up the right to file it elsewhere. I've also seen where people have changed their minds after. And like, oh, wait a minute, I do want to file it in France. I do want to file it in Mexico. And you have to petition, and I wonder oftentimes if they did this on purpose or not. But if you can get through the petition and convince them, they may allow it. But I wouldn't advise playing games like that. Just know that it's going to be published. Okay. And then, of course, the patent gets issued. And that's when you have your patent. Now, this is important, filing deadlines. Okay. So when do you decide to file? So it must be filed no later in the US than 1 year after the earliest of these events. These are the triggering events. If any of these happen, you have 1 year to file your application. So there's what we call the bar, on sale bar, public use bar, publication, or the last bullet point is the catch-all. If your invention is available to the public, and this is the language in the statute. It says, if the invention is otherwise available to the public, a 1 year time clock starts. And if you don't file your application within that 1 year, you have forfeit the right to get a patent. That's why this is very important. And this is why I stress, when I love it teaching people, but this is, if you get nothing else from this presentation, keep that in mind, that if you release your invention, you have 1 year to act, or it's over. This is important because this 1 year grace period, it's only available in the US. This is the part of how serious this is. If you have an invention, and this is how it happens. You have an invention, and you need to start contracting manufacturers, machine shops, whomever, to start, how am I going to create the widgets and the parts and all that? So you think instantly, oh, I'm going to send them a picture of my invention. I'm going to send them a description. That's a disclosure. You have disclosed your invention without protection. That's considered it's going to fall in that camp. The problem is, if you didn't file an application anywhere in the world before you did that, you have forfeit the right to patent outside of the US. The US is the only one that gives you that 1 year. And I run into this, and it's so sad, because I'll get a call, hey, I've got this idea. One of my questions is, have you published this? And if they tell me yes, then if they did it without protection, then I have to give them the bad news. Then I say, legally, the only place you can file is in the US if your disclosure was less than a year ago. So you might ask, well, how are they going to know? How's anybody going to know? And a lot of people get away with it, and you may, but again, remember, and I've been on this end of it too, where you're litigating a patent, and you've got a big company that's put millions of dollars into their technology, and they have their patents, and somebody's copying them. They're not going to bat an eye and spending another $1 million on attorneys to start the deposition, start discovery, and it will unravel because somebody's going to have to substantiate that they didn't do this, and it'll fall apart, and your patent will be rendered invalid. So, if nothing else, remember that. 1 year, the key thing, okay, before I should mention too, so how do you avoid this? You avoid this if you have to disclose to the machine shop supplier. You get them to sign a confidentiality agreement. It's a simple 1 or 2 page agreement saying, hey, I'm giving this to you, but you have to keep it in confidence. They sign it, as long as you get that's legally enforceable. And then you don't trigger this 1-year grace period. There was a question?
Yeah, so if I'm selling in another country, but in that country I actually have a patent filed, does that year still come into play?
Yes, yes, in the U.S.
In other words, if I'm selling in Mexico, but I have a Mexican patent,
Mhm.
so, and I began at January 1st this year, I still need to file for a U.S. patent before the new year?
Within 1 year, it's an excellent question. Most countries, there are certain treaties. One of them, the most common for patents, called the Paris Convention. And this was many, many years ago, where industrialized nations decided, hey, rather than have our inventors, why are we going to force our inventors to file 50 applications? It's just too expensive. Why can't we just all agree, if my inventor in France files an application here, we're going to give you 1 year to file it in the U.S., in Great Britain, and we'll honor the initial filing as long as it's made within the 1 year. So it all comes, that 1 year is kind of a magic time frame.
I have a question.
Sure.
So when it comes to like capstone projects, let's say engineering class, you have a senior project, it then becomes to like a product that you want to put in the market. Does that count within the year, or like it can be after?
It does, because remember, this last prong, if it's invented otherwise available to the public, that starts that time clock. And so I want to give you this so that's why it's critical. And a lot of people, they trip on this because they don't know that this the aspect of patent law. But here's what I mentioned the confidentiality agreement. That's one way. But that's only so manageable, right? If you've got a group of 200 people, you want to show your paper to, because you need to publish, how are you, nobody's going to realistically send out, give out 200, I want you all to sign these. You're not going to get them all back. So one thing you can do is, remember I said the key thing was to have it filed. You have to have your application filed. That's the key. So the U.S., hey, the U.S., great. We have such a really lenient patent system. It's really one of the best. The U.S. allows you to do what we call a provisional patent application. And what this does is it buys you 1 year from the day you file the provisional to decide if you want to go full-blown, like, yes, I want to proceed with the patent application. It's basically a placeholder. It establishes the priority date for when you're, again, first to file rights. New matter will not receive the priority date. So if we file a provisional today, and then a month from now you decide, hey, I'm going to add a whistle and a lever here to my invention, it only covers what was filed in the original. What you could do is we could file a supplementary provisional. And as long as you tie them all in within 1 year, the protection's there. But each iteration, and this is giving you a lot here, but each iteration would only start protection from the time you filed. It does not count toward the 20-year time frame. So you actually get an extra year in your life of your ultimate patent. And what happens if it's abandoned? Because oftentimes this happens. I've had inventors who, they want to protect the, and after I explain to them, like I did to you, like, hey, we need to file it or get confidentiality agreements. Say, okay, let's protect it. Let's file a provisional. And then you find out, well, okay, I'm not getting the seed money I needed for investment, or I changed my mind, or hey, we've found a new development, that old design is no longer workable. We're not going to proceed. You don't have to do anything. You just walk away from it. You don't touch it. And after the 1 year period hits, the patent office considers it to be in a black hole. Nobody will ever, they're never published, you never see them. So you can imagine there are probably millions of abandoned provisionals in the patent office that we'll never know of. Some examiner may have someday decide to publish, I don't know. And it's also cheaper, too, to file a provisional. The cost and the attorney's fees is a different story. It depends how elaborate you want to get, how formal. But one caveat that I give for provisionals is a lot of people think, oh, it's just a placeholder. I don't have to be as thorough as I would if the regular. And you actually do need to disclose. You need to consider it as if you were doing a regular application in terms of disclosing everything. But it's just under a provisional cover. All right, post-grant. This is oftentimes people think, oh, let's get all these patents. Once you get the patent, you have to maintain it. Basically, in essence, the patent office charges you a tax. And this is worldwide. Every patent office, that's how they survive. You have to pay a tax. Overseas, they call them annuities. We call them maintenance fees. Same thing. Here in the US, after your patent's granted, for the 4 years out, there are 3 tiers of fees. There's a large entity, small entity, and a micro entity. It depends where you fall. The values I'm giving you here are for the small entity. If you qualify as a micro entity, which would be like, I think it's like 250,000 threshold, and it's like you don't have more than 3 patents. There's a certain guidelines. You could file under that, and it's half this price. So it depends where you fall. The Microsofts of the world, they actually pay more. This small entity is 500 or less employees that you qualify for these fees. Now, so at 4 years out, you'd have to pay $1,000 to maintain that one patent. 8 years, $1,880, and 12 years, $3,850. If you don't pay those fees, the patent goes abandoned. Sometimes it happens where the administrative end, they fall down and somebody misses the payment. You can make a late payment. You'd have to submit a petition. And I don't know what the record is, but some have actually revived very late patents. They've been able to do it. I don't recommend it. This is why you keep track of it. The point I want to make here is that when you think of these big companies and you read that they have thousands of patents, like IBM is notorious. They love to hold that banner as we're the #1 patent filer in the nation. And I think they still are. They like their numbers. They like to boast how they file so many patents a year. Yeah, but all of those patents multiply these maintenance fees per patent. It's a huge, huge revenue. It's a budget. Another thing too, it's kind of a well-kept secret, is the Patent Office is a huge revenue generator for the US government next to the IRS. Because everything you do, you will have to pay a fee. I mean, very few things you get away with submitting without a cost. And I mean, rightly so. They have 6,000 plus examiners, and et cetera, but a lot of fees are paid by patent holders. Reissue application. Let's say you get your patent and you realize, after you see it published and everything, you realize it was an error. You can go back and correct it if the error was without deceptive intent. You can try, these are really minor things. You can try to correct some technical details. If you filed a reissue within 2 years after the grant, you can actually broaden your claims if you can substantiate the broadening. Patent marking. This we used to see often, and you still do. You may still have some products where you'll see the actual patent and a number engraved, printed, a label. That was the old school, and you had to do that, and this is what you would see, US patent, whatever, designation. Up until, again, 2011, 2013, we went to virtual marking here in the US. So virtual, by definition, now you can create a website where for your goods, your services, you just list the patents that cover the certain products, and that will meet the standard. The importance of marking is that without the marking, it limits your the infringer's liability. Tax and infringement committed after receiving formal notice of infringement. What this means is damages. If somebody's infringing your product, and if you haven't marked it, you won't be able to get back damages, meaning lost profits, reasonable royalties, until they receive formal notice. That's if you don't have it marked. But if you have it marked, you can go back 6 years. And that could be millions, depending on how many damages you've lost. So virtual marking now, the US has made it very easy. It's a website. You can go in there and delete expired patents, et cetera. You can add them as they pop up. The terms, patent pending, patent applied for. You can legitimately use this after the application is filed. I get questions sometimes where this happens a lot in-house in companies where the inventors will submit an invention memo to the patent department or to their lawyer, and can we use patent pending? No, until it's actually filed in a patent office. That's when you hold it out, patent pending. And what's the importance of that, right? What's value? It's just a simple notice to the world and competitors that to be aware, and it goes to what we call willful infringement, which it goes in the infringement aspect, which a lot of detail, but just that's it. All right, the heart of every patent is the claims. This is when people talk of patents, like this is what we're talking about. I showed you before Phil Robertson's, they had the cover and they had the figures. Well, every patent will have a list of claims, basically a paragraph spelling out an apparatus having bell A tied to whistle B, et cetera. The reason importance of this is that this defines the scope of the, quote, invention. this is really what it's protecting. It's what's used as a checklist for infringement. When you're saying, hey, you're infringing my patent, this is a term we use it loosely. We say, you're infringing my patent. But what we're really saying, and then when you file a claim before the court, you say they're infringing claim 5, claim 2, claim 3. You're infringing claims. So that's what we use for the checklist. It's what the examiners use to go through the prongs. They use the literal claims to meet whether or not they meet the standards. A patent can have as few as one claim or an unlimited number. I've seen one patent like 300 claims. That cost a pretty penny to file, but each claim stands on its own. So your first claim, your broadest claim may say a chair comprising a back, a platform, 3 supports, and a plurality of rollers. Okay, let's say that's your main claim. And your second claim says, oh, the apparatus of claim 1, further including a telescopic support, something like that. All right, so you've got 2 claims, you've got your patent. All of a sudden, you assert it to somebody, and they say, wait a minute. 10 years ago, somebody built this same chair, the base, et cetera, the legs. All right, so your first claim is knocked out. It's invalid. But if that 10-year-ago chair didn't have that telescoping support, then your second claim will survive. So each claim stands on its own. Think of each claim as a mini patent. So that's one of the things when we file applications, and if you work with your attorney, your agents, you want to make sure this is very important. Your claims, you get them as best you can, and sometimes you want more rather than less because you can't. You always wish you had more, especially in trial. And I mentioned this before. Are we dealing with an issued patent or a published application? That goes to enforceability. All right, patent infringement. It's anyone without permission from the patent owner that makes, uses, sells, or offers or imports. Basically, you violate one of the exclusive rights. You can still get ambushed by late issuing patents. You may start today in your garage, your home. You start producing some software and you sell a product, and a week from now you get a notice letter, cease and desist, by somebody that their patent just issued last week. If you can't invalidate that patent because there was prior use or prior art, then they can legitimately block you. You're infringing. It's what's called late issuing ambush. It can happen. Independent creations are relevant. Unlike copyright infringement, where you actually have to prove copying, you don't need to prove that somebody copied your invention. It's either it falls within the scope of the claims of your valid patent or it doesn't. Damages, I mentioned before, you have up to 6 years to go back to collect damages, provided you use virtual marking or you actually mark the goods. Otherwise, you only get damages from the time of notice forward. Induced and contributory infringement. The U.S. also, not every other country has. The U.S. has provisions under our statute where you can actually sue somebody if they were an inducer or a contributory infringer. This has to do with intent. If you are aware that company A has a certain patent and you're selling a product that okay, it may not be infringing, but if somebody combines it with something, they're going to fall under patent A. And you know this, and you sell your product knowing you're inducing others to infringe. Or if you go beyond that, you fall into the contributory infringer, you can be liable, not just the person directly infringing, you can be pulled into that as well. There is an intent element. So that's why a lot of times it's difficult to prove, because if it was innocently done, sometimes you can get out of that. But just be aware that is a prong. A little bit of U.S. patent history, and I'm getting close to the end here. So a little bit of a history here. So the U.S. Patent Act was passed in 1790. The first examiner was Thomas Jefferson. You can imagine him as the first patent examiner. The first patent that officially issued by the U.S. was titled "A Method of Making Potash." I guess that was big back then. and that was number 1. Okay, and then the millionth patent came out in 1911. So for a vehicle tire, we can see where we're going here. Progress, innovation. All right, but the point is, it took 121 years to get from 1 to 1 million. And as you see here, I'm going down the list to the 3 million, 4 million, 5th million, or whatever, going on. All right, so you see the increment. They're getting closer and closer in time. We're down now to just over 11.5 million. If you see the second to last bullet point, U.S. patent number 11 million was issued last year. Last year also we reached 11.5 million. So now we're going to less than 2 years. The patent office is issuing 1 million patents, the U.S. patent office, whereas the first million took 121 years. So it's kind of give you an idea of how much activity patent-wise, and that's just the U.S. I mean, I'm sure other nations they can do the similar analysis.
Do you think it's because innovation and technology is accelerating?
Yeah, I think definitely innovation, and nowadays, if you want to be viable and survive, you have to patent, because you will be copied. If not for patents, there would be no Samsungs. All the competition would be wiped out. So you want to protect your whatever it is, your service, your widget, your development. I just, if it turns out to be valuable, it's almost guaranteed someone's going to want to copy. So yes, that's why it's nowadays it's kind of like in academia. The publisher perish now. It's patent or get taken over. Oh, I'm showing you here. This is just recently issued last month, the 31st. This company out of I think it's in Dallas, Droplet Inc. They have a patent that it was granted in 2004, and they just successfully won a lawsuit against Yahoo for $15 million. The patent covers a way to access website information without having to pull up the whole website. And if they thought of it back in, they filed in 2000. No, they did a provisional in 99, issued in 2004, and they just won a suit. So it's kind of giving you a little idea, like, yeah, you can have something you may not think is so valuable, but it can be. So my recommendation is if you have ideas for anything patentable or like I mentioned before, the other protection vehicles, but for patenting, go to Google Patents, very powerful tool. You can do searching there, where I talked about doing the prior art search. Google Patents is a great vehicle. The U.S. Patent and Trademark Office, of course, you can look at their database. You can just do a general web search, and I do this a lot. Like, before I even go to the patent sites, I'll just type in description of a product, because remember before, one of the prongs is novelty. So if you start seeing images pop up of whatever someone thinks is an invention, there may not be anything patentable. Publications. Publications, not too many people look at them nowadays, but before the internet, there were services where people would actually go to the Patent and Trademark Office and physically have to look through paper files. You'd look at institutions like the technical publications. People would scour through those, depending on the technology. And then, of course, if you really want to go full-blown, contact an attorney or an agent. The difference between attorneys and agents is the attorney has a law degree. The agent is registered before the patent office, but they don't have law degrees, and generally going to be a little cheaper. This is the way it is. And you may think, fine, an agent. I don't have anything against agents. I think they do great work. But I have to, as an attorney, I have to say what you would be missing out on is, the studying of the case law, the thing about patents, particularly the nuances. There's a lot in there, and if you don't study the case law, the agents aren't going to have that background. But they do great work. I can tell you, one of the companies I was with, one of our patent agents wrote about 5 patents and this is public info. They did if you know about drilling, it was with Schlumberger. I used to work with Schlumberger, and they did a drill bit, the actual device that bores into the ground. This patent agent worked with a couple of inventors. They got a family of patents for the literal bits that go at the end of the drill, the head, to actually literally cut into the rock. They were so successful that they were generating at one time over $100 million in royalties a year. Very, very, and an agent wrote it. So I'm saying, I don't have anything against agents. Just be aware, if you want an attorney, it's going to be different. We all know what this is, so here's just my pop quiz. Okay, how many think this has copyright protection? How many think trademark protection? Patents, trade secrets, all the above. All the above. Exactly. Yeah, exactly. It's like, yeah, IP covers so many things. And, oh, sorry, that was it. You guys had good questions. If you have any other questions, I'm free to, yes?
Are there instances where the federal government, specifically the executive branch, can suspend the execution of a patent? Let me give you a specific example.
Mhm.
Oh,
Yes. No, that's a great question. So, yes, you're asking if the federal government can step in. Yes, they can, and they have, especially in pharmaceuticals. They have, and there are also, I'm pointing, it's a good question because this is a great example. Okay, we would not be able to have these phones and all the stuff we do if there weren't some, I don't want to say mandatory licensing, but encouraged licensing, because the hundreds of patents that are behind this technology, if the patent owners didn't want to license, we wouldn't be able to use these products because they would hold on to their rights. No, you can't use them. So the government started, it's called FRAND, I think, the act. It's like fair, reasonable, and something else licensing. Basically, what they call essential patents. If some patents are issued for what is considered essential technology for the public good, then there's a statute now that they have to negotiate for fair and reasonable licensing. So that's an example of the government stepping in and saying, yes, you will do this. But and in this case, it's very good. Again, without that, these things wouldn't be in the market. All the patent holders, they could say, no, you can't use it. The manufacturers, their hands would be tied. It also happens with funding. The Department of Energy and DOJ, but no, I think it's the Department of Energy. You can make applications to get funding to help you pay for your IP development. In return, though, you're granting them what they call march-in rights. So when you get your patent, they automatically have the right. If the government wants to use it, they don't even have to ask you. You've already given them that. That's the trade-off. Yeah, we'll give you some funding, but if we want to use it, we will. So yeah, I mean, as you can imagine, the federal government is pretty powerful in what they can do. Any other questions? Yes.
I was just going to ask, can you talk a little bit about the software aspect and what may be patentable, not patentable?
Okay, excellent question. Sure, software. Wow. Right now, that is a hot topic because for the longest, all you had to do, and for patents, we couch it as a process. So the claim would be a method for, I don't know, I'm trying to think of an example, a method for producing stranded DNA samples or something of that effect. And you would put something like, okay, inputting a data set of DNA buffers, or I'm making this up, but you see where I'm going, okay. And then you'd put, okay, the output is a display. Years ago, you could get that patent if it met the novelty, non-obviousness hurdles. Up until, I don't know, 2014, I think it was, the Supreme Court issued this one opinion, it's called the Alice opinion, where they just, wow, made it super hard to get patented software. Now you have to pass a higher threshold. The big thing right now is the examiners are using, if they can point to your claimed invention and say, oh, well, that's a mental process. If this can be done strictly in the mind, they're going to reject you. You're not going to get a patent. I can tell you, it's very, very hard to get a patent. So today, to get a patent, you have to somehow tie it very firmly to something physical, that your algorithm, even though some part of it may be done mentally, you may be able to do some calculations, you may be able to do these derivatives. Yeah, sure, you could do them in your head. But in the process, it's tied to some physical thing that's outputting, or that you require that machine, then that may be patentable. So you have to get away from the abstract idea. That's the big hurdle right now. So the answer is still very patentable. It's just a lot trickier. And you have to really tie it to something physical or something that you can show that no, it's beyond the mental capacity. That we need software to do it. Machine learning or AI, you have to get into that realm. Somehow show that this is something that is beyond what the mind can do. And then you're more apt to get a patent.
like a recommendation engine?
Something to that effect, yes. Something that, yeah, because right now that's the biggest rejection they're using. They're based on this Alice decision. They're saying, hey, that's an abstract idea, therefore not patentable. And it's very difficult to overcome that. Sometimes you can't. Sometimes you have to appeal. That's a whole nother area of patent law. There's an appeal board, and then you can always go to trial, the federal court. I mean, it depends how much money you have to spend to try to prove to get your patent. You had a question?
Yes, sir. So my question does kind of relate to money. I met somebody who worked with Schlumberger, and she designed a drill bit, and it did really well in South America. She signed off all of her IP rights, so she gets like a nominal, kind of like a thank you fee from that because it did well. I took Brenda's UCIE class, the Certificate of Entrepreneurship, and it talked a lot about the growth of like lean startups in America.
Mm-hmm.
And those, when we were designing that business model, I mean, $500 was a big difference between like, can I get this advertised? Can I get like a draft of a product to show to somebody? When I was trying to think about a patent for this little invention of mine, one thing that was brought up was talking to a lawyer. And again, I bring up the lean startup model because you don't want to spend that money, or you want to allocate your resources as efficiently as possible. So I guess my question is kind of like, at what point for this modern entrepreneur do you think you need to get a patent versus when do you need to spend those money on like other startup costs?
Sure, great question. Well, I point back to, and that's why I said if you get nothing else from this, remember that 1-year grace period, what starts that clock ticking? And it's a disclosure, anything that puts your invention out in the public in some fashion or other. So if you can protect it with a confidentiality agreement, that's the easiest way. That's really not very costly. It's a 1 or 2 page agreement, have the other party sign it, and it's enforced. If you can't do that or they are unwilling to, then I would suggest a provisional patent application. And that nominal fees, again, is because you're basically setting a placeholder. But that's the key. My answer would be you need to decide also if you're willing to play with that 1 year, but you're giving up your right to file abroad. Because remember, the strictness of that rule was if you don't have it on file at some patent office anywhere in the world, you forfeit rights outside of the U.S. So if you're willing, if that's okay, then fine, go forward and show it for trade shows, whatever, and realizing you have 1 year from the first public instance to file that application.
So if you do a provisional, you forfeit the right?
No. If you don't have at least a provisional or a regular, if you don't have any file application filed and you display it, the door closes in Japan, France, and UK, everywhere outside of the U.S. That's how strict it is. I mean, that's like, you think about it, that's, wow, people that aren't aware of this, how, yeah, if you want to protect it, you have to do it up front. Any other questions?
I
Yes.
guess I'm kind of bouncing off that one a little bit from the investor standpoint. So investors always seem, especially big ones, always seem to catch it when it's teeny tiny, almost before it's made it out public.
Mhm.
Is there a way, from an investor standpoint, they get in before it gets published? Or
What do you mean the investor standpoint? Yeah, okay, let me answer it this way. If you are the one seeking the seed money, then yeah, you'll want to disclose. And again, those are more controllable under the confidentiality agreement to the extent that that investor pool is willing to sign it. Because some of them, they realize what they're doing, right? You're committing, I'm not going to disclose this until it becomes publicly, or you give them that right. And a lot of them are reluctant. They'll say, no, come back, this happens. They'll say, come back to me when you have a filed application or a granted patent. Sometimes they're just they're the strict rules. But if you file, that's the easiest. It's like, yeah, okay, I have something filed, and then it's a protection for both sides. And I want to dispel a myth. Nobody's asked this, but there used to be this myth that, oh, hey, if I just put it in an envelope, right, the invention sent to myself, that's proof. Well, that's irrelevant now. It was not workable before, but even less now because we're the first to file. When we used to be the first to conceive, that's where people thought they could do that, to show as proof that they came up with it first. But no court of law really looked at that. But now it's irrelevant. Either you filed it first or you didn't. Any other questions? Well, thank you very much. You've been great. Oh, yeah.
One question, because I'm just also curious. When it comes to NFTs, there's like novel like art up in the blockchain. Like, do you foresee that conflicting with IP law?
NFTs?
Yeah.
Please help
Like
me.
the non-fungible
Oh, yeah, okay, yeah.
tokens?
Conflicting with patent law?
Yeah. So like now that it's on blockchain, it's transparent,
Mhm.
it's out in the public. Is there protection on that, or you have to file while you do NFTs as well?
I figured it would be trademark, right? Most of the
Depends what you're trying to protect, right? Because remember, trademarks is the origin, the source, right? So if you want that, yeah, you need to protect. If you're doing that service under a mark, a logo, a chime, whatever, yes. But if you're trying to process, then you have to patent. That prongs apply across the board.
So let me shine a little light here. So when you talk about an NFT, you generally talk about probably some JPEG file or derivative or something else. So that's why I was saying this is probably more in a way of copyright or trademark because it's not unless you're illustrating a process, which in and of
Mhm.
itself the illustration, the NFT is generally a picture of something.
Yeah, and you're right. In that case, it would fall under that if it's copyrighted or trademark, because you're looking at what is the article. But if you want to, I guess I'm looking at more of the protection, somehow protect some service or process. But you're exactly right. If it's something viewable, particularly, yeah, copyright is either they have it or they don't. It's held out some designation to authorship or sponsorship, then yeah, trademarks. Yeah.
Can you speak a little bit to piggyback off of this?
Oh, no, business method. Sure, sure. Yeah, that's an area where the last has gotten stricter. Because again, you can file, most people think of patents, you think of goods, which is it's proper. You think of a transmission, a widget. Okay? But then you get, again, we went to the software, that's not so tangible, and we cover those by method. That's how they're always going to be couched in the, let's say, a method of, a method process. And when they started coming out, like I think people are aware of the Amazon, the wars where they first started coming with business methods for the one click and all of that. As they met the threat, novelty, peaceful, not obvious, they were getting granted. What was happening then, all of a sudden, we realized because they were 20 years, how can they get a patent on something we've been doing? So they and that's if somebody asserts a business patent against you and you can prove that you were this was something that you were doing or it's been in the public, that process before filing, you can invalidate. So that's that out. All patents are presumed valid when they're granted. But it doesn't mean they can't be knocked out. And that's validity. And again, how much money is at stake. Because again, if you get a deposition, you get discovery, you have to divulge information. And any of these little strings, you start pulling on, the whole thing can unravel. What I was saying to you before, you hear from selling and pouring. You sit down with the engineer on the team that developed that patent. So tell me again, when did you first conceive? What did you do? And information is coming out. And if you can prove, oh, wait a minute, 1 year before you filed, that's how you validate. So they're all presumed valid, mean they're not challengeable. And you won't know this unless you go through that process.
Well, let's give it a hand to Ms.
Thank you.
Thank you so much.
Oh, thank you.
Well, and just like a last point, I would love to see you guys at our certificate courses happening this fall. Please share with your friends. We are still having some slots. We are half. We're up to 30 students, so we have up to 15 already registered. So please make sure to share it. I mean, these are electives counted for you. We have scholarships, so this could be a free certificate for you as well. And plus, we'll do sort of a Shark Tank sort of competition. So for those in the cohort, they will be actually pitching to our mentors and advisor boards, looking through our ideas or products that come out of the class. So please don't miss out. Talk to your advisors. Registrations is open right now. Cool. Thank you, and good luck on your